Charged with assault of a pregnant person as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in the prison and up to $10,000 fine. Court is calling 2024 CR 007456 State versus Gustavo Jimenez. Can I have parties announced?
Brandon for the state.
Rene Munoz on behalf of Mr. Jimenez.
And are you Mr. Jimenez?
Yes.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor, that's correct.
Court will find that the state is in compliance with discovery. Mr. Jimenez, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Right out of the gate, this case carries serious weight: assault of a pregnant person. That's not just another assault charge. Courts treat this as especially severe because there are potentially 2 lives at risk. And notice how quickly things move: discovery confirmed, indictment acknowledged. This tells us one thing: we're heading straight toward resolution, not a drawn-out trial. The real question is, what kind of deal is about to unfold here?
Judge, we have a few amendments to talk about before that. The state will still be making oral motion to amend count 3 of the indictment, specifically that in between where it says cause bodily injury to, and then hereafter style the complainant, it should read Oryan, Oryan, Summer.
1 second.
Of course, Judge.
Okay, now I'm ready.
Okay, it should read Oryan, Oryan, Summer, like the season, Sky, SKY, and then Herring, HERRING.
All right, any objections to that amendment?
No objection from the defense, Your Honor.
All right, Mr. Gustavo Jimenez, you understand that is a substantive change to the indictment?
Yes, ma'am.
Knowing that, do you still wish to proceed?
Yes, Your Honor.
All right, and the court will note for the record that the state is adding that to count 3, but in count 1, it does have that name listed as the complainant. So the court is going to also find that the defense is on notice that that's the name of the complainant as it appears in count 1 as well.
Understood, Your Honor.
All right. So now that that amendment has taken place, are you proceeding only on count 3?
Yes, Judge. We'll be proceeding solely on count 3 and waiving and abandoning the remaining counts.
No objection.
All right. Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
You're charged with assault of a pregnant person as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in the prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
That's correct, Judge. And if I just may speak briefly on that topic, I've been able to communicate reasonably and clearly with my client ever since he's been deemed restored. He was at the Kerrville State Hospital for competency restoration services. In my opinion, that treatment did take. He was deemed competent and referred back to this court. In discussing the case strategy and the possible disposition of this matter, my client has notified me he wishes to waive the defense of insanity and proceed with the plea at this time, as he's competent at this time, and he does wish to make that waiver, and which is knowingly and voluntarily made. All
right. Mr. Jimenez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promise you anything other than the plea?
No, no.
Are you satisfied with the way you've been represented? No, well, here's the thing. I understand that sometimes people want certain things, but I always tell people a defense attorney can't force the state to give somebody what they want, right?
I could have got NGRI since my offense was. I can't be in the hospital for 20 years because the offense is 2 to 10.
Now, let me explain something to you, Mr. Jimenez, about the law, because I've done a lot, right? So I've represented clients as a defense attorney, when they had mental health issues, right? Now, let me explain to you about NGRI pleas, not guilty by reason of insanity pleas. Like the public doesn't understand sometimes, the public will believe that if somebody gets a not guilty by reason of insanity, that means that, oh, they got off. Sometimes a not guilty by reason of insanity for a person's client, it's worse for the client in the sense that the length of time that you are supervised is whatever the range of punishment is. Now, on another part, it's sort of good for your client because your client is supervised, your client has case managers. So your attorney, and I'm sorry, I overheard a little bit, your attorney is correct. So you have 3 counts in your indictment. Count 1 is aggravated assault with a deadly weapon. Normally, if you're just on your standard probation, the length of time you're allowed to be on probation for this specific law offense is 10 years. But with a not guilty by reason of insanity, that aggravated assault, you're supervised for 20 years, whatever the range of punishment is. So for example, if you're charged with murder and you do a not guilty plea by reason of insanity, your range of punishment would be supervised under that NGRI plea is life. So for you, count 1, you're looking at 20 years of supervision if you were found not guilty by reason of insanity. Count 2, you're looking at 20 years of supervision if it's not guilty by reason of insanity. Count 3, which is a 3rd-degree felony, you're looking at 10 years. Now, if you want to do a not guilty by reason of insanity plea, I don't know, you all will have to negotiate, but then the state may be saying, no, we're not just going on count 3. We're going on count 1, we're going on count 2, and we're going on count 3. So that's where we are. You understand?
Yes.
So are you satisfied with the way you've been represented?
Yes, Your Honor.
All right. If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, Your Honor.
All right. The court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
All right. According to the plea, the state is waiving counts 1 and 2.
This is where things get really interesting. The judge just broke down something most people completely misunderstand. Not guilty by reason of insanity isn't a free pass. In fact, it can mean longer supervision than prison. Think about that. Instead of doing a fixed sentence, you could be monitored for decades. So now the defendant is stuck in a high-stakes decision: take a guaranteed deal or risk a much longer, uncertain future. What would you choose in that moment?
They're only going on counts 3. They're asking that your punishment be assessed at 10 years in the prison. Did you understand that to be your plea?
Yes, Your Honor.
Defense and state, is that the plea?
That is the plea, Judge.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Judge.
Then to count 3, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Judge, we offer to say exhibit number 1, including all attachments.
Without objection.
All right. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Off the record for a moment. Is the door unlocked?
It's unlocked, Judge.
Okay, thank you.
Yes.
All right, we're back on the record. Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor, if we may.
Anything you wish to say on behalf of your client?
Well, Judge, Mr. Jimenez has been in custody ever since this charge. He's been battling competency issues. He was in custody about 300 days before he got transferred to the Kerrville State Hospital, at which time he was restored to competency.
They can come in.
He successfully completed those days at that Kerrville State Hospital from February 11th, 2025 to July 17th, 2025. We'd be asking the court to grant credit for his treatment that he was getting for competency restoration. My clients did learn a lot, and he has come a long way once I first got the case to how he is now, understanding the court proceedings. He did tell me that he does suffer from degenerative disc disease, and he wanted me to let the judge know about that, to see if there's any way that TDCJ could be made aware of that in advance. I told him I had never made that request of the court, but that the judge here, Ms. Stephanie Boyd, would be able to opine as to that, and he seemed comfortable with that, Judge. But he wanted me to tell you about that issue that he has with his physical health. His mental health has come a long way, which I think, reading the offense report, the court is able to grasp a better sense of the things that he was dealing with. But we're asking the court to respectfully accept the plea offer recommendation from the parties, and to give him credit for all the time he's entitled to.
Okay. So after reading the police reports and everything, I understand that there were more issues that were going on with you, that this wasn't something you just did because it was, oh, let me just hurt somebody. So I understand. But you're going to have to make sure that you stay on your medications and not mix anything else with medications. A lot of times people will self-medicate, right? You can't do that because then you end up here, right? So I'm going to find you guilty. I'm following the agreement. I'm going to sentence you to 10 years in the prison, give you credit for any time served.
And there it is, the final outcome. The judge follows the plea agreement, locking in 10 years. But notice the tone, this isn't just punishment, it's also about management. Mental health, medication compliance, structured placement, the court is trying to reduce the risk of this happening again. That's the balance in modern criminal justice, accountability on one side, rehabilitation on the other. But here's the big takeaway: when you combine violence with instability, the system doesn't gamble. It contains.
I know that you were residing with your parents. Are there any minors in the home?
No,
Okay.
my parents are 88 years old. I'm
Yeah.
80.
But I mean, sometimes, grandparents end up taking care of grandchildren. That's why I'm asking. So there's going to be no residing in households with minors, no unsupervised contact with minors. And then there is going to be, I think I said I'm going to give you credit for any time served. I'm going to ask for the therapeutic community, the mental health unit. And also I'm going to have them put in there that you suffer from physical health issues. Now, while you're at the jail, your medical record should follow you to the prison. And they will also, at the prison, they will do a physical and everything for you. If that doesn't happen, just let us know. I'm sure, let your attorney know, let me know. But your medical records usually follow you to the prison. Okay. And then when you're processed at the prison, they will do a process where they will process you in, and they will get all of your medical history, all of your mental health history, and it'll be on the judgment as well. So they'll know that I've said that there's some issues. Okay.
I'll have a history of my medical issues in the Kerrville Hospital.
Yes. And you'll receive credit for the time that you were in inpatient treatment at the hospital as well. So legally, you're supposed to have that. And Mr. Munoz, if you'll make sure that the time credit is correct.
Yes, Your Honor, will do.
All right. Did you review the trial court certification of defendant's rights to appeal with your attorney? It's the document telling you whether or not you have the right to appeal.
Yes.
Did you understand it and sign it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over that, you need to speak to an attorney, okay?
Yes.
And when you're released from custody, we're off the record, when you're released from custody, I know you're probably gonna want to go back and stay with your parents. So it'd probably be best for you if you talk to them or talk to your brother beforehand and find out if the persons who were complainants in this case are still there, because you don't want to have any problems, okay?
No, I don't wanna live over there
Okay.
at all. We live in another place.
All right. Well, make sure you stay on your medications. And if for some reason there's some side effects, you got to let the doctors know you're experiencing side effects, okay? All right. Good luck to you, sir.
Thank you. Have a good day.
Oh, you too. Bye-bye.
Good, Judge.
All right. Thank you. Court is calling 2022 CR 3617, 2022 CR 3618, State of Texas versus Rami Yandu. Can I have parties announced for the record for the state? For the defense?
Sean Sheffield.
And are you Rami Yandu? Counsel, in each of the cause numbers, have you received all the discovery and did you review that discovery with your client?
I did.
Then in each of the cause numbers, the court will find that the state is in compliance with discovery. In each of the cause numbers, I'm showing you what's entitled True Bill of Indictment. Did you review those documents with your attorney? Did you understand them? Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented in each of the cause numbers?
Yes, Your Honor.
Mr. Yundo, in each of the cause numbers, I'm showing you what's entitled Court Admonishments. Did you review that document with your attorney in each of the cause numbers? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
In each of the cause numbers, you're charged with the offense on unauthorized use of a vehicle. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights in each of the cause numbers?
Yes.
And did you intend to give up those rights in each of the cause numbers and enter into a plea bargain agreement?
Yes.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses to this offense?
Yeah, I do.
Do you believe he has a rational as well as a factual understanding of the charges against him? Do
I do.
you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
In each of the cause numbers, Mr. Yono, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each of the cause numbers, I'm showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
In each of the cause numbers, punishment is to be assessed at 6 months in the Bexar County Jail under 12.44. Each of the cause numbers were run concurrently. State will take in consideration 2022 CR 5522, 2022 CR 3616, County Court cause number 680088 and 680931. Did you understand that to be the plea bargain agreement in each of the cause numbers?
Yes, ma'am.
Defense is at the plea bargain agreement.
It is, Your Honor.
State is at the plea bargain agreement.
It is, Your Honor.
In each of the cause numbers, I'm showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offense and as charged in 2022 CR 3617, how do you plead? Guilty, not guilty, or no contest?
Contest.
And in cause number 2022 CR 3618, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's plea.
Yes, in each case, the state needs to admit to the more distinct exhibit 1 into evidence.
No objection.
In each of the cause numbers, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review those documents with your attorney? Did you understand them and did you sign them in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
In each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. In each of the cause numbers, the court is finding there is sufficient evidence to find you guilty, and the court is finding you guilty. Are you proceeding with sentencing?
Yes, sir.
Anything you wish to say on behalf of your client?
Your Honor, we just have to follow the recommendation before the court. It does have credit through federal time, Your Honor. So we just ask the court to allow that time.
All right, is this just judgment satisfied, state?
Yes, it's Your Honor.
It is, Your Honor.
All right, in cause number 2022 CR 3617, the court will sentence you to 6 months in the Bexar County Jail under 1244. Give you credit for any time served, show that the judgment is satisfied. This run concurrent with 2022 CR 3618. Take in consideration 2022 CR 5522, 2022 CR 3616, County Court cause numbers 58008. I'm sorry, correction. It's County Court cause number 6800888. County Court cause number 6800931. And then in cause number 2016 CR 3618, court will follow your agreement. As previously stated, the court is finding you guilty, will sentence you to 6 months in the Bexar County Jail under 1244. Give you credit for any time served. This is run concurrent with 2022 CR 3617. Take in consideration 2022 CR 5522, 2022 CR 3616, County Court cause number 6800888 and CC 68093. And the court will show that the judgment is satisfied. Is there anything else from either side with regards to sentencing?
No, Your Honor.
In each of the cause numbers, did you review a document entitled Trial Court Certification of Defendant's Rights to Appeal? Did you understand it and did you sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. Did you understand?
Yes, ma'am.
If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. People don't like you riding in their vehicles when they're stolen or riding on motorcycles that are stolen. You ruin the car for the owner when you do that. You understand? If you want a vehicle, then you need to get a job and earn it. Do you understand?
Yes, ma'am.
Otherwise, take the via bus or walk or get a bicycle.
Yes, ma'am.
All right, good luck to you.